In previous lessons, we noted that one of the sort of elements relating to illegality as a ground for judicial review was this idea of relevant considerations, i.e., a failure on the part of the executive or the public authority to take into account the relevant considerations, or, as a counterexample, they're taking into account of irrelevant considerations when making a decision. This lesson is going to discuss this in a little bit more detail. We're continuing our conversation about illegality. We're talking about illegality as a ground for judicial review. This lesson, as I said, is talking about the nature of relevant considerations in this particular topic. Now, relevant considerations, according to LexisNexis, are, quote, those which the statute conferring the decision-making power either expressly or impliedly requires the decision-maker to take into account. So, relevant considerations, the word relevant considerations, the word relevant in this particular part, doesn't seem to attach the same kind of weight that LexisNexis actually does when they think about what relevant considerations actually are. Because according to LexisNexis, they're not just considerations which are relevant to the making of a decision. They are the things in a statute which are either expressly or impliedly required to be considered when making a decision. It means that when, in the course of making decisions, a public body or statutory authority or executive authority, the statutory authority may oblige the public body to take into account a number of considerations when making a decision. If they fail to do so, then there can be a successful ultra vires illegality-grounded judicial review claim. If such consideration is taken into account, or the counterpoint to this, if considerations are taken into account when making a decision, but those considerations are irrelevant, okay, they're not part of, or either expressly or impliedly part of the statute, then the action may be challengeable by way of illegality. A useful illustration of this can be seen in the 1983 case of Bromley LBC versus the Greater London Council. Now, this was a case in which the Greater London Council had acted to implement a manifesto pledge, which would involve the reduction of the cost of tube and bus rides. So, of course, every single council, every single general election, council elections, even the elections that have just gone, that came and went a couple of days ago at the time of recording, they all obviously have manifesto pledges, and when you get elected, you have a mandate to implement those manifesto pledges. One such manifesto pledge for the Greater London Council in 1983 was the reduction of the cost of the tube and bus rides. This would be done with the issuance of a levy rate of 6.1 pence in the pound to supplement the reduction of this cost. And this is a very useful example and a very useful illustration of whenever there is a manifesto pledge that requires or that pledges or seeks to essentially reduce the cost of something, you always have to ask the question, okay, well, how are you going to do that? Now, bear that in mind, because of course there is likely going to be a general election this year, or maybe early next year. Bear in mind, the time of recording this lesson is the 5th of May 2024. If you read a manifesto and they say, we're going to reduce the cost of X, Y, and Z, you always think, well, okay, how are they going to pay for this reduction in cost? Because reducing cost is fine, there's less money going to whoever it is that cost is actually incurred onto, or given to. So, one such example here is the fact that they had pledged in the manifesto to reduce the cost of tube and bus rides, and they said they were going to do so by issuing a levy rate of 6.1p in the pound, and this would supplement the cost. This reduction would be by way of a grant to the London Transport Executive. Now, this was something that they had the authority to do, or allegedly had the authority to do, under the Transport London Act of 1969, specifically Section 3 of the Transport Act, the Transport London Act. Again, the Transport London Act is probably another piece of legislation that all of you law students are going to be rushing to read from cover to cover, given just how interesting it sounds. Fundamentally, one of the things that the Greater London Council, however, did not take into account is the fact that it is not just Section 3 of the Transport Act that they needed to consider. because Section 7, subsection 3 of the Act obliges that the Greater London Council take into consideration the duties of the London Transport Executive when it comes to the exercising of its powers under Section 3. Now, it was held that the powers granted in Section 3 had been utilised unlawfully, and the reason why it had been utilised unlawfully was because it failed to take into consideration the duties that the Greater London Council had towards its ratepayers. So this is an example of a failure to take into account a relevant consideration, a consideration that is obligatory in the issuance of such essentially such reduction in costs, and essentially the duty towards their ratepayers that the Greater London Council failed to take into consideration of. We have two quotes here that illustrates this point nicely. So the GLC of course just standing for Greater London Council, insofar as it considered that it has a commitment to bring about the reduction in fares, regardless of other considerations, misdirected itself in law. So again, regardless of other considerations, they failed to take into account the relevant considerations that would be required in making such a decision. Therefore, the decision was considered to be unlawful. The Greater London Council could not have considered the London Transport Executive was complying with its obligations under Section 7, subsection 3. So they only really looked to Section 3 of the Transport London Act, but rather they should have also taken into consideration the relevance of Section 7, subsection 3 as well. And this is a useful illustration of how relevant considerations or irrelevant considerations can give rise to an illegality claim under judicial review.